Thank you to the HCCH for the opportunity to contribute to this closing session of the Digital Economy Relationships track of the CODIFI conference, with a special focus on human-centered finance and trade for sustainable development. My name is Craig Atkinson, and for the past decade, I've worked as a consultant with the International Trade Center, ITC, the joint agency of the United Nations and the World Trade Organization, with a capacity-building mandate for small business, trade support entities, government officials, and policymakers, especially those from developing and emerging markets. Currently, I'm also a research fellow with the joint Stanford-Vienna Transatlantic Technology Law Forum, the TTLF. I began my career in accounting and finance positions before roles in export development and commercial diplomacy with two national government agencies, the Australian Trade Commission and the Canadian Trade Commissioner Service. Given my background in using technology to facilitate relationships between economic actors, especially small business compliance with trade regulations and their capacity to form cross-border contracts, my applied research focuses on computational law and the legal technical bases for digital forms of commercial rules that extend accessibility for humans and enable operationalization by machines. This field of research has relevance for both public and private branches of law and provides a way to bridge the analog-digital governance gap. Thus, in this presentation, I'll begin by framing the discussion around the problems associated with rules and jurisdictions in digital trade. Secondly, I answer the question, what is computational law? Thirdly, I raise some key questions regarding the nature of legal relationships mediated by digital technology. Lastly, I describe which of the UN Sustainable Development Goals that a body of computational trade rules may contribute to in the context of supporting instruments, such as those developed and maintained by the HCCH. So to begin, there's a problem of rules and jurisdictions in digital trade. Today, the physical and legal separation of parties to a transaction is common, but cross-border transactions can be complex, time-consuming, costly, and risky, as parties must comply with rules under different domestic legal systems and in the context of international, interstate agreements, while also forming private contracts and meeting their obligations. At the same time, emerging technologies are shifting the way cross-border interactions between regulatory authorities, businesses, and consumers are conceptualized and governed, including the resolution of disputes. Although there is no one definition, the OECD, WTO, and IMF jointly describe digital trade as trade that is digitally ordered and/or digitally delivered, and define digitally ordered as the international sale or purchase of a good or service conducted over computer networks by methods specifically designed for the purpose of receiving or placing orders, and digitally delivered as international transactions that are delivered remotely in an electronic format using computer networks specifically designed for the purpose. In this way, the growth of the digital economy is altering the scope of governance that pertains to information and communications technology, ICT. This includes governance for ICT, such as legal recognition of electronic transactions, governance of ICT, such as regulations on the processing or cross-border transfer of data, and governance by ICT, such as compliance systems and computable or smart contracts. Consequently, trade tech, or what has been described as the set of technologies and innovations that enable trade to be more inclusive, efficient, and equitable, can help to fulfill this new category of governance by ICT, yet these approaches require legal, technical bases. To date, significant outputs such as the United Nations Commission on International Trade Law, UN Central Model Laws, have addressed legal recognition for early-stage digitization, the conversion of paper-based analog sources of data into a digital form, such as electronic document formats that can be processed by a computer. To support digital trade facilitation, this includes domestic requirements for paperless trade, the public improvements to the legality and efficiency of trade administration through measures that convert paper-based trade document systems into electronic formats, and international coordination of cross-border paperless trade, cross-border mutual recognition and exchange of trade data and digital documents through institutional and operations mechanisms. As more goods sales transactions are conducted across borders via electronic means, there's also an even greater need for frameworks that clarify party autonomy, whereby parties to a contract determine which set of legal norms is best suited to their transaction. Ultimately, according to the UN Global Survey on Digital and Sustainable Trade Facilitation, although numerous measures have been implemented, more work remains to be done in digitalizing trade processes. My present research investigates computational law and digitalization, data-enabled process improvements to advance standardizability of computational legislation/regulations and contracts to break the silos between diverse actors and commercial systems, including hard and soft law instruments. Then, what is computational law? Computational law, or comp law, has been described by Stanford University's Michael Genesareth as the codification of regulations in precise computable form. It reflects informatics concerned with the capacity of machines to provide legal analyses and processes on behalf of humans. Computational law also addresses the automation of private obligations, such as contracts, financial rules, and internal business rules, such as those for pricing. Some contributions to the field of computational law are enhancing the accessibility of rules for humans via information tools. Going further, other approaches allow for the operationalization of proxy representations of law as algorithms by machines, such as through government systems and private platforms. To support this, new logic programming techniques have emerged to express natural language rules in computable forms, including domain-specific languages such as L4, and using tabular declarative methods such as the Data with Direction Specification, DWDS, rule schema. So why does it matter for trade? Also referred to algorithmic law, digital versions of rules can extend the functionality of data. Given Mitchell's definition of human-centered automation, the use of automation technologies can enhance the capabilities and compensate for the limitation of human operators. The development of sources of computational law can benefit from the hard and soft law infrastructure for international commercial transactions and facilitate digital trade. Whether through smart contracts on a distributed ledger or the compliance software system of governments and third-party solutions providers, computational law has already started to shape the operational architecture of international commerce. In addition, as a branch of informatics, computational rules research and development, R&D, depends on data sources and is inextricably linked with semantic and data standards work. For example, comp law R&D complements digital ID initiatives for the legal identification of commercial and/or financial entities. Although computational rules can help to bridge the gap between the written word and electronic mediums for the operationalization of rules, they also create challenges. In particular, new technologies and innovative configurations of existing technologies raise questions related to private international law. For example, distributed decentralized systems may create transactional ambiguities related to the identity of parties and location or situ. Other questions include, what are the nature of legal relationships between parties? Do private contracts formed via digital protocols satisfy formalities to be considered binding legal contracts? When disputes arise in relation to the terms of a digital protocol-enabled agreement, how can or will a court interpret the agreement? What remedies are or will be available to parties to enforce legal rights? How can or will a successful party or parties enforce a court's decision? Although the answers to these questions are not entirely clear and depend on the jurisdictional context, many see transnational sources of law as supportive to solve these problems. Along with other sources of international law, the HCCH texts can complement the development of computational law for trade. The Hague Conference on International Private Law, the HCCH, develops and maintains international conventions and soft law instruments. The core HCC instruments are the 1985 Trust Convention, the 2006 Securities Convention, and the 2015 Principles on Choice of Law in International Commercial Contracts, known as the Choice of Law Principles. Designed to promote party autonomy in international commercial contracts, The choice of law principles are the organization's first soft law instrument and are endorsed by the United Nations Commission on International Trade Law and the International Chamber of Commerce, among other bodies. The principles act as a template for the creation, reform, or interpretation of choice of law regimes at the national, regional, or international levels. Generally, as sustainability refers to pursuing approaches that equally consider people, planet, and profits, a supportive infrastructure of legal instruments helps to connect legal systems. In tandem, the development of a body of comp law has the potential to directly contribute to at least 6 of the 17 United Nations Sustainable Development Goals, SDGs, namely Goal 8, Decent Work and Economic Growth, Goal 9, Industry, Innovation, and Infrastructure, Goal 10, Reduced Inequality, Goal 11, Sustainable Cities and Communities, Goal 12, Responsible Production and Consumption, Goal 17, Partnerships to Achieve the Goals. In particular, for Goal 8, by fostering the participation of small business in digital trade, comp law can enable governments to achieve goals related to the labor market, as small enterprises account for most of the employment worldwide. The increased cross-border economic activity can also help national governments to increase revenues. To conclude, computational law provides a way to bridge the analog-digital governance gap. In this presentation, I frame the discussion around the problems associated with rules and jurisdictions in digital trade. Secondly, I describe the potential for computational law to provide new opportunities to standardize approaches to trade process improvement and create interoperability across legal and information systems. Thirdly, I raise some of the key questions regarding the nature of commercial relationships mediated by digital technology. Lastly, I describe which UN Sustainable Development Goals that a body of computational trade rules could contribute to, with supporting instruments such as those from the HCCH. As the digital economy continues to grow, technology presents new opportunities and challenges for international commercial rules. There is a mutually reinforcing relationship between the development of a body of computational law and transnational sources of law, including uniform sources of private international law. Thank you again to the HCCH for the opportunity to contribute to this closing session of the CODIFI conference.